Welcome to the False Claims Act Insider, presented by Price Benowitz. With more than 15 years of experience as an attorney focusing on qui tam law, Tony Munter explores the risks and heroism involved in being a whistleblower alongside distinguished attorneys.
You're Stephen Jaffe of the Stephen Jaffe Law Firm. You came to doing whistleblower work the more traditional way. That is to say, you started out with being an employment lawyer and sort of somewhere along the line came across this stuff and got into it.
That's absolutely correct. I can tell you exactly how this happened. Back in 2009, I had a client walk into my office and say to me, my employer just cut back my salary by $30,000 a year because I didn't make my recruitment quota. Can they do that? And I said, I have absolutely no idea, but I'll be glad to look into it for you. And that case was my first FCA case. And it's still going on because it's now a famous case, because it's been up to the Ninth Circuit, it's been to the Supreme Court, it's had 5 motions in front of the trial court, and that was how I got into this. And it was inadvertent, but I really think it's kind of a natural evolution of whistleblowers. You know, people who come to see you as an employment lawyer are usually very unhappy in their jobs, or really angry because they've just been fired, and wanting some retribution or revenge is not uncommon.
Well, you had to become an expert in a particular kind of False Claims Act case, and I kind of want to talk to you about it because it seems to me a lot of the regulations around for-profit education have been in flux over the past 4 years, to say the least. It may or may not have affected the law with respect to your case, but I don't know of anyone who knows this area better than you. How is the case going? For people out there to know, you have a particular kind of a False Claims Act case, and it's out of seal, so you're in a position to be able to talk about it.
Yeah, the case I'm discussing, or that we are discussing here, is a violation of what is known as the incentive compensation ban, as they pertain to for-profit higher education. I can do a little summary of the policy and the reason behind that. When you're dealing with public institutions or nonprofit private institutions, particularly the upper tier ones, the federal government has zero concern that the funding of student loans and Pell Grants is being given to people who shouldn't get it. If you're trying to get into Harvard or Yale or UCLA or anything like that, the competition is so great that by the time the requests for federal funding come along, there's a very high level of confidence that the people asking for it deserve it and ought to get it. Exactly the opposite is true when you're looking at for-profit educational institutions. They exist to state the obvious, to make money.
Yeah.
So they don't care how qualified their students are. All they care about is that there's a warm body in the seat that's going to receive federal funding, and that funding goes, without getting into the weeds here, goes directly into the bank account, not of the student, but it goes in to pay their tuition at the higher education institution. So the feds are really a cash cow for these for-profit institutions. Yeah. So what the incentive compensation ban does, which are Department of Education regulations, it's not a statute, it's a reg. What it says is when you have people working for you and you're a for-profit institution, you cannot compensate them like a used car salesman. You can't reward them for enrolling more and more and more people just by the number of people they enroll, because that disincentivizes them to enroll qualified people. And a lot of money that's going out in a Pell Grant or a subsidized loan is going to wind up going to pay for the education of people who really shouldn't be there. So it prohibits that kind of enrollment measured compensation. So everything was fine up until George Bush got elected. When George Bush got elected, he came in and he changed some of the regulations to create what was known, it's a term of art, called a safe harbor. Safe harbor is a euphemism for a loophole.
Yeah.
Where the higher education institutions could, in fact, find ways to circumvent the incentive compensation ban. And that created a lot of litigation over what's within or without the safe harbor. When Obama got elected, he immediately set about putting in people to repair what Bush had done and undo the safe harbor, which they actually did. Took them longer than I would have liked. It took them until 2010 to do it, but they did it. But they did undo it.
Okay.
I do not think Trump messed around with that, which is kind of amazing, considering who he had in place in the education department.
Really
Betsy
is.
DeVos, who never met a for-profit institution she didn't love. But she's gone now too, and hopefully we will get some more stringent enforcement of the incentive compensation ban. But that's what the case is about in a nutshell.
It's quite a case, and the incentive compensation ban, you're right, I'm kind of surprised that it wasn't removed, because it's basically a regulation, as you say. It's not, a statute. So it did kind of fall under Betsy DeVos's purview, I suppose. She certainly didn't do anything to create any more regulations that would make it possible to sue a for-profit organization in the education sphere, which may be why we haven't seen very many other cases in this area, in spite of, your case involves millions of dollars and thousands of students, if I'm...
The big development during the Trump administration was, well, actually, it's not just limited to incentive compensation ban, something that you're extremely intimately familiar with, which is the Escobar case.
Sure.
Which affects all FCA cases.
Well, I was going to ask how you thought that would affect the incentive compensation ban. And just briefly, Escobar, in our view, stands for the proposition that an implied certification can be a false claim, but it raised to the surface something that's always been there, perhaps, the question of a materiality. That is to say, the claim made against the United States has to be seen to be a material issue, or that is to say, the falsity has to be material. You have to be able to show that the government in its right mind might not have paid, is the bottom line.
Right. And what comes up in the incentive compensation ban cases is very often there's a history of either the government knowing or should have known that there was a violation of the incentive compensation ban, but they continued to fund students of a school violating it. The government's response to that has been, and the government has filed several amicus briefs and statements of interest in that case, is that, look, there are many reasons why the government, and this applies not only to the ICB, but to other kinds of cases as well. There's many reasons why the government might continue to pay defendants while they investigate it. Some of them are, and a lot of them are policy reasons. If you're dealing with a large institution like I am,
Mhm.
you're dealing with thousands of students. And the government does not want to, for lack of a better phrase, throw out the baby with the bathwater here and cut off funding for many thousands of students who legitimately are there and are legitimately pursuing higher education in order to punish their the institution they're attending. So there's a balance there about that.
I always think of this in terms of Medicare, Medicaid, and in terms of the concept. And there's a case in DC that's kind of raised this idea of a third-party beneficiary. And or the government being a third-party payer. And when you're talking about a student loan, the government is very involved in paying, but they're not really receiving the service. It's the individual student that receives the service. And so somehow, to me, I don't put a lot of credence in the sort of whole backdoor government knowledge idea that's being foisted on us through the Escobar case, but I could see it making a little more sense in the government procuring a bridge or buying supplies for the government directly. But here with your case, the government isn't really doing that. It's funding, Jane's students' college education, and they don't really directly get the service. And it seems to me it's a little unfair to hold the government to that sort of high standard of cutting off all the funding for a third-party beneficiary.
Well, I
Did
can
that come out in the fight, or how did it play out?
not in those words, but certainly there's been arguments made by the other side that the government is getting what it paid for, regardless of how the students were recruited. There obviously were, we have some anecdotal horror stories where homeless people were recruited, or people without a high school education, or people clearly unqualified to go to college, but they were enrolled because they were enrolled because there's this thing called the stick date. The stick date is 6 weeks into the enrollment. And if the student that's enrolled is still there at 6 weeks, the money can be drawn down by the institution, the Pell funds and the subsidized loan, and it's irrevocable. At that point, the for-profit institution doesn't care if the student drops out or drops dead, because the money is in their pocket. So
Really?
So yeah, but I'm going to just touch on kind of what you're talking about in a way, and it's a war story. I have tried one FCA case which I lost and maybe should have lost, but for the reason that I'm going to tell you. It was an NIH grant to a biotech company.
Yeah, those are tough.
They clearly violated the regulations on their accounting. No question about it. But this outfit was doing research on the prenatal detection of birth defects, because the founder's sister had given birth to a child with severe developmental disabilities. So he founded the company, and they started developing these prenatal tests. Well, the jury heard that, and they didn't care.
They didn't care what they were doing.
Care how he accounted for the money, because in the end, and this was the argument that was made, and I don't know that I had much to say, the government got what it paid for. It got research. I mean, it funded the research. The NIH funded the research.
Right.
It got what it paid for.
So some extra trips to Bolivia, who cares, right? I mean, it's not a big deal.
Yeah, I mean, the guy, I didn't dislike him, but there was no accounting. It was just, but I lost, and that's why, and then I talked to the jury afterwards, and that is why I lost, and maybe I should have lost, but
But has that informed your thinking? I mean, the more I do this, the more, if I don't have a visceral reaction to the case.
Yeah, the answer is yes. It informs my thinking because now when I get a case, after that experience, I always ask myself the question, leaving aside the legal technicalities here, is the government getting what it's paying for? Is the government getting what it's paying for? And if the answer is an obvious yes, and if it has emotional kinds of components like that one did, where are you telling me you're against funding prenatal? Then I hesitate.
Well, I think it's kind of interesting because, we see the defense bar always saying that our side will take any type of case. And, there's not that many of us. There's not that many people who really do this stuff all the time. And that just isn't my experience with my colleagues. That my experience with my colleagues, other experience, we all know we're not getting anywhere with a case that isn't really strong anyway. And the longer you go on, the easier it is to see a case, how it won't work more than how it will. So I'm not surprised that it informs your thinking right now.
Yeah, no, I do that. Correct.
Yeah. I mean, I assume you get many more calls than you take. How many cases have you tried? Because not very many people have tried. You're in the middle of trying a major false claim. I say middle, but I mean, it's been going on for a long time. But how many of these have you taken to trial or tried to take to trial?
That's the only FCA case that I've tried.
You've obviously tried many employment law cases, and that's.
Oh God, I've lost count of the number of trials that I've had.
So you wouldn't be afraid to take a False Claims Act case to trial, assuming you thought you'd win it. I mean.
Yeah, it depends on how strong the facts are. That's right.
Yeah,
that's right.
And well, that's unusual. Most of us.
I would take the Academy of Art case, the private university case, to trial. I mean, there's some really egregious violations. There's lots of money at stake, which shouldn't have been spent, and their witnesses are highly dislikable, including the president and owner of the place is very just not
a good witness in your view.
That's right, very bad witness.
All right. Well, so maybe we'll come to a courthouse near us. I don't know. We'll
I suspect it'll settle because, I mean, right now the pandemic, everybody is crying poor.
Yeah, had that.
Which has raised a new area of inquiry for me, which is because I got a settlement conference together. I think it's the 5th mediation in this case that's coming up.
Oh my God.
But this may be the one that does it. But when a defendant comes to you and you're talking settlement, and I know this happens in every corner of the FCA universe, and the defendant's crying poor, are you supposed to just believe it? Or, I wasn't a big fan of Reagan, but one of his favorite quotes, which I pull out all the time.
Trust but verify?
Trust but verify, that's right.
Well, it's interesting because I just had a settlement in a case, and it's kind of complicated. It is more than one defendant, and the government intervened against a couple of them, but not another of them. And at least 2 of the defendants cried poor mouth, but they had to go through a process with the government.
The government has a section.
That's a little different. They have to submit, all kinds of material and tax returns, and
those are intervened cases, I think.
Yeah, and
mine's not. So
yeah. So, but
I'm on my own.
I guess I would say if they're going to go through that and claim poor mouth to that degree, you obviously must be entitled to some level of discovery on their finances. The only problem is you're not the government. You don't have the FBI. You don't have everybody else.
You've been talking to my AUSA. And, I've told her if we reach a settlement in principle, you should expect me to ask you, the government, to at least activate your section that confirms the financial condition of these places.
Mhm.
So I am going to ask the government because I'm sure they have an interest in making sure they're not being screwed or lied to also.
Well,
So,
they have the authority to, as crazy as it sounds, after you actually reach settlement, they still have to agree to it.
that's
So,
right. That's right.
you know, they at least have to conduct some level of due diligence if the settlement is based on representations to you about the defendant's financial condition.
Yeah.
It seems to me they're on the hook to at least look at it.
One of the things that's interesting, I mean, everybody is worried about the pandemic, obviously for humanitarian reasons and financial reasons. And there's lots of kinds of businesses that are just doing horribly. But there are other, and you don't hear about this, but there's other kinds of businesses for which this is an incredible bonanza.
Well, somebody's making money. The stock market's up, and
Well,
corporate earnings are
FedEx
up.
and UPS are going through the roof because of all the
Yeah,
online deliveries. Any business which was already involved in online kinds of activities is going to jump on this.
yeah,
I would add, including colleges, for-profit colleges. You know,
yeah.
so,
That's true. I hadn't thought of that. That there probably is a boom in for-profit colleges.
yes, there is.
And I would think, well, it's going to be interesting, but I mean, there's going to be a demand for Zoom college credits one way or the other, because who's gonna? I mean, I'm not sure people are going to want to spend $30,000 a year to live on a campus if they can get the same education, at least in theory, over Zoom.
Well, not only that, when the campus is closed down,
Mhm.
you're talking about a major drop in the expenses of the institution. They don't have to hire janitors. They don't have to heat the dorm. They don't have to turn on the lights in the classrooms. I mean, there's a lot of expenses that the college, profit or nonprofit, no longer has to maintain. And that's going to really kick up I mean, one of and I know I'm cynical, I sound this, but in my case, I'm cynical because that's going to kick up the profit margin quite a bit. So
Well, that's interesting. I mean, we'll see what happens with that industry, but they're not going to be the only ones. I think it's going to be interesting to see, though. I mean, there's going to be legitimate industries that do much better, and then there's going to be people that take advantage of it unfairly, and we'll just have to see how it plays out.
I don't know a lot of lawyers who are complaining they're going broke because of what's going on. I don't.
I hear a slowdown in business and in being able to get stuff processed through courts. There's, folks in my firm, there was frankly a slowdown in criminal defense work for some period of time, I think. There aren't as many car crashes, there aren't as much drunk driving, there isn't as much sort of garden variety, regular, what you would think of as normal criminal law work. But the stuff we do,
Well, I can tell you there's been no slowdown in employment law from the employee side.
yeah,
And FCA, I mean, has been going right along too.
going right along steadily. I think it's been, at least as far as I can tell, the Justice Department's been a little bit working on its backlog, I would say.
Yeah.
But I think that's actually more related to the last 3 or 4 months getting ready for a new administration, perhaps. There's a certain sense of let's, see what happens in 3 or 4 months. There's a sentiment within the False Claims Act bar that maybe Attorney General Barr was not the most sympathetic leader to the False Claims Act that has ever led the Department of Justice. You
never know with people.
You never really know, though. I mean,
because people who claim to be law and order and anti-fraud should be strong supporters of the FCA, like Grassley is.
yeah, sure.
But they also are strong supporters of business, which is not a friend of the FCA. So
we'll see how it goes. It's
right.
It's going to be interesting to see what happens going forward. It would be nice to think that we'll have a more aggressive set of regulations and maybe even an aggressive Department of Justice and Congress. There's a lot of things that need to be fixed, in my view. We need some sort of coordinated way to deal with Escobar, of course. And I haven't really heard it yet. We're still sort of like fighting on a case-by-case basis. And
Grassley proposed some new amendments to the FCA, which are still floating around out there. It's been a couple of months since that happened. He got sick.
Yeah, that's scary. Yeah,
very scary.
Yeah, it's very scary. It's funny that, I mean, people think that the False Claims Act is some liberal thing, but here we are living off of the work of an 87-year-old Iowa conservative Republican senator who, but for him, I guess there would be no False Claims Act at this point.
I wish him good health.
I do too. We need him. Well, Stephen, I can't thank you enough. This is great. What are you looking for coming forward? Do you see? Is there any kind of new case that you're seeing that we should be on the lookout for, or is it just you're taking them as they come? I'm sort of.
Well, I'm taking them as they come. What's I don't know if it's unique for an FCA practitioner, which I consider myself now.
Mm-hmm.
But I have yet to do a Medicare or healthcare case.
That's a little unusual.
All of my cases are non-Medicare, and they're very, very interesting cases. I've got one where a school district was defrauding the state of California and the feds for school bus money. And I've got one, I think my favorite one is I don't know how to describe it. The Congress appropriated, these are all unsealed. Mm-hmm. Congress appropriated funds for what's called VAWA, the Violence Against Women's Act, that claims a lot of credit for. And they funded training around the country for law enforcement people to deal with particularly domestic violence kinds of situations. Mm-hmm. Mm-hmm. And there's a private, semi-private kind of organization which trains cops all over the state of California. And they defrauded with the complicity of the sub-agency of the state. Because it was all cops and ex-cops on both sides. Mm-hmm. They defrauded the congressional funds for that. So it's a very interesting case, and the AUSA has been very helpful in that one, and she's filed statements of interest. And I actually made in that case, which I made a relator's side summary judgment.
Wow.
Later's, which is now pending.
Wow.
I'll be glad to send it to you if you want.
I would love to see that.
They really don't deny the facts that I've alleged. They're just saying their defense is kind of, so what? That's the way we always did it.
Wow. So you really went for it. We'll see if that works out.
Because they agreed with all the facts I alleged. They never disputed any of the facts.
Well, that sounds like summary judgment to me.
I mean, that's right.
That's
right.
Yeah, well, good luck. I really hope that works for you.
So, I mean, the practice has been very, very interesting.
Yeah. So, well, it is. Look, these are the most interesting cases. I've got one I have to talk to you offline because I may need a California counsel on it. Right. These are, I started out, didn't do very much Medicare initially. Then I've done, of course, many since then. But these are the most interesting cases any lawyer could ever hope to be involved in. I mean, I think that's why when you talk to lawyers who've done other kinds of work and wind up doing this, why they keep doing it, because they're just always big, important cases that matter about something big and important.
They're very high level. You're dealing with smart lawyers all the time. Mm-hmm. Dealing with, I mean, it's a three-sided case. all the time.
Mhm,
Intervention or not, you're always dealing with the government,
mhm,
and that's a high level of practice.
mhm.
So you're not dealing with fender bender kind of
Yeah.
PI cases and insurance adjusters. So
Yeah. Yeah,
it's,
no, it is.
it's gratifying in that way.
Yeah, it's a very high
Right,
level of work. I think that's true, and it
Right.
keeps us on our toes.
right. Well, very, very enjoyable.
Great pleasure, Steve. Thanks so much for your time. I know you're busy. I'll get back to you soon.
Okay, thank you, Tony.
Pleasure, Steve. Thanks.
Thanks for tuning in to this episode of the False Claims Act Insider. Be sure to check back next week for more insights into the world of whistleblower and qui tam law with your host, Tony Munter. All episodes can be streamed on pricebenowitz.com along with your favorite streaming platforms.